Welcome to StudyVic's YouTube channel. Always study smart and master your future. Today we are commencing a truly crucial audio lecture dedicated entirely to mastering one of the most rigorously controlled areas of corporate finance under the Companies Act, 2013. We are embarking on a thorough exploration of Chapter 5, Acceptance of Deposits by Companies. This statutory framework, spanning Sections 73 through 76A and the accompanying rules, is absolutely central to corporate compliance. Getting this analysis right as well is non-negotiable for anyone operating in the financial and legal space.
That is the perfect starting point. For you, the aspiring professional, this chapter is really the key regulatory control over how non-banking corporate entities raise finance, whether it's from their own members or from the public. It establishes a necessary safety net designed primarily to protect depositors, individuals who get their savings from undue risk. Our goal today is to go beyond just listing the rules and instead understand the policy, the rationale underpinning these procedural safeguards.
Right. So our mission in this audio lecture is to provide a clear, detailed roadmap. We need to logically define deposit, meticulously categorize and, frankly, memorize the huge list of exemptions, the negative list, and then internalize the strict numerical limits and tenure requirements, and critically understand the severe personal and corporate liabilities that come with non-compliance.
Exactly. And the most logical starting point for mastering compliance is, maybe counterintuitively, defining what isn't a deposit. We start with that critical negative list because if an amount you've received fits squarely into one of these exemptions, then all the burdensome procedural requirements of Sections 73 and 76, they just vanish.
Okay, let's unpack this then. The first and I think largest compliance challenge is the legal ambiguity. Section 231 defines deposit with this sweeping inclusion. It covers any receipt of money by way of deposit, loan, or in any other form. That scope is deliberately massive, isn't it?
It is massive by design. The legislature wanted to ensure that no creative accounting or, financial product could be invented to escape regulation. Every single receipt of money, unless it's explicitly carved out, is potentially a deposit.
Okay.
However, the saving clause is equally critical. It excludes amounts prescribed in consultation with the Reserve Bank of India. That exclusion list, detailed exhaustively in Rule 21C, is your playbook. We can categorize this huge list of exclusions into 5 logical buckets. It just helps with memory and understanding.
Let's begin with amounts received from sovereign or highly regulated institutional sources. The underlying policy here seems to be if a regulated entity is the source, the debt is already safe or, regulated elsewhere.
That is precisely the policy rationale. We start with government and statutory authorities. That's the first one. Any amount received from the central or state government or where repayment is guaranteed by them is excluded. This also covers amounts from a local authority or any statutory authority constituted under an act of parliament or a state legislature.
The regulator trusts the sovereign guarantee.
Exactly, and the oversight that comes with it.
Now, if we look internationally, the list of exempted foreign sources under Subclause 2 is, it's vast. Why such a blanket exemption for foreign funds?
Because foreign financial transactions are already under the very stringent oversight of the Foreign Exchange Management Act, or FEMA. That provides a parallel regulatory structure.
So it's to avoid double regulation.
It is. We exempt amounts received from foreign governments, foreign or international banks, and major multilateral financial institutions. The source material specifically mentions entities like the IFC, the Asian Development Bank, the CDC, and the IBRD.
Right.
This category ensures that standard international project finance or cross-border lending isn't hindered by our domestic deposit rules, provided, of course, that the company remains fully compliant with FEMA.
Okay. And moving to domestic financing, the law also exempts standard commercial funding from highly regulated local entities. That's under subclauses 3 and 4.
Yes, this covers loans or facilities from entities like public financial institutions, regional FIs, insurance companies, or scheduled banks as defined under the RBI Act, 1934.
So a standard term loan that a company takes from, say, State Bank of India or HDFC Bank.
That term loan is not a deposit. Think of it that way.
I remember the Prize Electricals Limited example. The director mistakenly believed a term loan from a bank counted as a deposit. The simple compliance insight there is that bank loans, which are already highly regulated, are generally outside this framework.
They absolutely are. And Perhaps the most frequently used exclusion in this category is the intercompany deposit, or ICD.
Wow.
Any amount received by one company from another company is exempted. This exclusion is huge for routine corporate group funding, financing between holding, subsidiary, or associate companies without triggering all these rules.
Okay, that makes sense. Let's shift our focus to funds raised through specific financial instruments. We have RBI-approved instruments, and the main one is commercial paper.
Right. Commercial paper, or CP, is an entirely separate short-term funding market. It's governed strictly by RBI guidelines. The logic here is straightforward. If the RBI already regulates the instrument and the issuance process, the Companies Act doesn't need to double-regulate it under Chapter 5.
Simple enough. But the more complex areas seem to involve debentures and bonds. Non-convertible debentures, NCDs, have very specific conditions to avoid being classified as deposits. What are the dual hurdles they have to clear?
2 critical requirements, and they must be met simultaneously. First, the NCDs must be unsecured. This means they do not constitute a charge on any of the company's assets.
Unsecured. Got it.
Second, they must be listed on a recognized stock exchange, adhering to SEBI regulations. If both of those conditions are met, the regulator considers the instrument publicly monitored and liquid enough to be excluded.
So if a company issues, say, 20 lakhs in unsecured listed NCDs, it falls outside the deposit definition. But if they were unlisted or secured...
The exemption would fail, exactly.
And what about secured debentures? How are they treated?
Secured bonds or debentures are exempted only if they are compulsorily convertible into shares within a maximum period of 10 years.
So there's a future equity commitment.
Yeah. But the security itself has to meet very strict tests. The charge must be created only on assets referred to in Schedule 3, and this is vital, intangible assets. Things like goodwill, intellectual property, trademarks are explicitly excluded from being used as security for this purpose.
Only tangible assets.
Only tangible assets. And furthermore, the amount of the debentures cannot exceed the market value of those specific tangible assets, which has to be assessed and certified by a registered valuer.
That distinction, no intangible assets, only tangible ones, shows a clear regulatory preference for easily realizable concrete security when public money is involved.
Absolutely. Now let's discuss what you might call the compliance landmine of this section. Subscription to securities. Share application money.
Right. Initially, this money is exempted, but it carries what you call the 60 plus 15-day trap.
It really is a trap. It's a high-risk area for young companies raising initial capital.
So could you elaborate on how quickly this can transform into an illegal deposit?
Okay, so the company receives the application money. If it fails to allot the shares or securities within 60 days, that failure triggers the start of a 15-day grace period.
60 days to allot.
Then the company must refund the amount within 15 days after the end of that 60-day window. If the company fails to allot and fails to refund within those total 75 days, the law retroactively treats the amount as a deposit.
Wow.
And not just from day 76, it treats it as a deposit from the date of expiry of the 60 days. So from day 61 onwards, you are holding an illegal deposit without even knowing it.
That is the ultimate compliance retroactivity bomb. It transforms what you thought was an equity instrument into a highly regulated debt, subjecting the company to all sorts of penalties. And the rule explicitly prevents creative maneuvers, right? You can't just adjust that money towards something else.
Precisely. The rule clarifies that adjusting the application money for any other purpose is not deemed a valid refund. It must be a genuine monetary refund, or the deposit classification kicks in. No exceptions.
Okay, let's move to the third category. These are amounts from specific persons, internal stakeholders, where the funds feel more like capital contributions than public savings. Let's start with the director, or a relative of a director.
The exclusion for funds from a director of any company or a relative of a director, but only in a private company, is highly conditional. The policy here is that the law will exempt this source only if it is provably internal capital and not, a secret channel for third-party deposits.
So what are the mandatory hurdles for this exemption to apply?
2 parts. First, the director or relative must provide a written declaration to the company at the time of giving the money, stating explicitly that the amount is not sourced from borrowed funds, loans, or deposits accepted from others.
So they can't just borrow money from a friend and then loan it to the company and claim the exemption?
No, absolutely not. For example, there's a case where a relative of a director got the money as a gift from their mother. Since a gift isn't a borrowed fund, the declaration was valid and the money was excluded.
And the second part?
The company must transparently disclose the details of the amount accepted in its board's report. This maintains regulatory visibility. So, for Polestar Traders Limited, which received a loan from Director Rachana, the compliance officer's immediate check must be: did Rachana furnish the declaration, and was it disclosed in the board's report? Failure on either count makes the whole amount a deposit.
Next up, the employee security deposit. This seems incredibly straightforward, but you mentioned it carries a painful numerical trap.
It is deceptive in its simplicity. A non-interest-bearing security deposit received from an employee is excluded only if the amount does not exceed the employee's annual salary under their contract.
Let's look closely at Ratnakar's case study. His annual salary is 6 lakh rupees, but the company demanded a deposit of 6,50,000. What's the consequence there?
This is the critical point. Since the deposit of 6,50,000 exceeds the annual salary of 6 lakh, the entire amount, the full 650, is disqualified from the exclusion. It's immediately classified as a deposit.
Not just the excess 50,000.
No, and that's the trap. The whole amount is tainted. The company must either reject the excess or treat the entire 650 as a deposit and follow all the rules.
That's vital. It's an all-or-nothing rule. Okay, finally in this category, promoters' unsecured loans, the ones tied to institutional debt.
Yes, this is a practical carve-out. It's a recognition that banks often stipulate that promoters inject their own unsecured funds before the bank will disperse its loan. So if the promoter or their relative brings in an unsecured loan because of an explicit stipulation from a lending bank or financial institution, it's excluded. The FI's own monitoring is seen as sufficient protection.
But what happens when that institutional debt is cleared?
The moment the bank's loan is fully repaid, the regulatory justification for the exemption disappears. Consequently, the promoter's unsecured loan instantly converts into a regular regulated deposit.
So the company has to immediately comply with all the deposit rules for that amount, or just refund it.
Yeah.
Okay, category 4, business advances. Funds received in the ordinary course of business. For advances for goods or services, the key seems to be time.
Yes, the clock starts ticking immediately. An advance for goods or services is excluded only if the company uses that money against those goods or services within a strict deadline of 365 days.
And if they breach that 365-day limit.
It converts into a deposit. The only relief is if the advance gets stuck in legal proceedings, in which case that 365-day clock is paused.
And we also have exemptions for long-term contracts for property and capital projects.
Right. Advances for immovable property are excluded as long as they're adjusted per the agreement. Same for advances for long-term projects for the supply of capital goods. These are complex transactions, they take longer, and of course, standard security deposits for contract performance are also out.
What about for long-term future services, like a warranty or a maintenance contract? There's a cap on that, right?
There is. The rule exempts these advances, but the period can't exceed either the common business practice for that industry or 5 years from the date of acceptance, whichever is less. This stops companies from disguising long-term loans as maintenance prepayments.
And you mentioned a critical caution that connects several of these business advances back to the deposit definition, where operational failures create compliance catastrophes.
This is the ultimate regulatory safety net. If an advance for goods or property or capital projects becomes refundable, maybe the company couldn't get the necessary licenses or permissions, that amount is instantly deemed a deposit.
When does that conversion happen?
It happens if the amount is not refunded within 15 days from the date it became due for refund. It's an immediate trigger that the finance team has to watch like a hawk.
Let's quickly wrap up the negative list. Category 5, other specific exclusions. We have non-interest-bearing amounts held in trust.
Simple custodial arrangements, yes, but the more modern one, the startup convertible note, is highly specific and, again, fraught with technicality.
What are the conditions there?
This is to help DPIIT-recognized startups raise early capital. The note must be repayable or convertible into equity within 10 years. Crucially, the amount received must be 25 lakh rupees or more, and it has to be received in a single tranche.
And that single tranche detail is what tripped up Greedwood Limited in the example.
It's a classic trap. Greedwood, a recognized startup, received 20 lakh on one date and 10 lakh later. The total was 30 lakh, which is over the threshold. But because it wasn't received in a single tranche of 25 lakh or more, the entire 30 lakh fails the exemption test and is classified as a deposit. Precision is everything.
And finally, a reminder about the blanket exemptions under Rule 1.3.
Right. The entire deposit framework doesn't apply to entities that are already under strict regulatory oversight from other bodies. So this includes any banking company, any NBFC, and any housing finance company registered with the National Housing Bank. They have their own, often more stringent rules.
Okay, we have successfully navigated the very complex maze of what legally counts as a deposit. So the next critical stage for any compliance professional is establishing the how much and how long parameters. Let's look at the mandatory tenure and the maximum ceiling limits.
Exactly. The law sets firm boundaries on the maturity period. The general rule establishes a floor and a ceiling. First, deposits cannot be accepted or renewed if they are repayable on demand. That's just forbidden. Or for a period of less than 6 months.
6 months is the statutory minimum.
It is. And the maximum exposure time.
36 months.
36 months or 3 years. This range, 6 to 36 months, prevents companies from funding very long-term projects with potentially volatile short-term deposits. It's all about managing risk for the depositors.
However, the law provides a vital short-term exception to that minimum 6-month rule. But it seems to be hedged with extreme caution.
It's a limited privilege, for sure. Deposits repayable earlier than 6 months may be accepted, but only if 2 strict conditions are met. First, the minimum tenure must still be reasonable. It must be repayable on or after 3 months. You can't raise 30-day money this way.
And the second condition is a quantitative limit. This involves defining the company's capital base.
It does. The aggregate amount of such short-term deposits is tightly capped. It cannot exceed 10% of the aggregate of the paid-up share capital, free reserves, and the securities premium account. We should think of this aggregate as the company's capital shield. It's the measure the regulator uses.
So if a company has a capital shield of, say, 5 crores, they can raise a maximum of 50 lakhs under this short-term window, and the repayment has to be after 3 months minimum.
Exactly. It provides necessary flexibility without compromising stability.
Now, let's apply that capital shield concept to the overall ceiling limits. The permissibility and the quantum seem to depend entirely on the company's legal classification. Let's start with private companies.
A normal private company is heavily restricted. They can only accept deposits from their members, and the total ceiling is 100% of their capital shield. And crucially, they are completely forbidden from accepting deposits from the public.
But the law has created special exemptions for certain private companies, granting them a no-limit status from their members.
Yes, there are 2 classes of what we can call special or exempted private companies. The first is any DPIT-recognized startup. For the first 10 years of its life, they can take unlimited deposits from members.
And the second type, the general exempted private company, has to meet 3 very stringent cumulative conditions.
They're designed to weed out financially fragile entities. 1, it must not be an associate or subsidiary of any other company. 2, its borrowings from banks or corporates must be less than the lower of twice its paid-up share capital, or 50 crores.
That's a key financial test.
It is. And 3, it must have no subsisting default in the repayment of those existing borrowings. If it clears all 3 hurdles, it can take unlimited deposits from its members.
That's a powerful incentive for private companies to keep their external borrowing low and maintain immaculate repayment records.
It is. Now, for public companies, they're far more regulated. First, only an eligible public company can access public funds. This requires a net worth of at least 100 crores or a turnover of at least 500 crores, plus passing a special resolution in a general meeting.
And what is the maximum quantum for these eligible public companies?
The total maximum limit for deposits is 35% of their capital shield. But this limit is strictly bifurcated. Deposits accepted from members are capped at a very tight 10% of the capital shield.
Only 10% from members.
Only 10%. The remaining portion, deposits from the public, can go up to 25%. The regulator is signaling that even for these big eligible companies, the risk exposure to their own shareholders should be minimal.
So it's high external access, but low internal member access.
Correct. For an eligible government company, they get a total ceiling of 35% with no bifurcation required, reflecting that sovereign backing. And finally, if a public company is ineligible, it fails the net worth or turnover test, it is absolutely forbidden from accepting deposits from the public. It's limited to members only, capped at 35%.
Okay, so having established the what and the how much, we have to move into the procedural backbone of compliance. Section 73 and 76, the operational rulebooks.
Yes, these are the rigorous steps required to establish transparency and fiduciary duty before any funds are accepted.
It all begins with formal authorization. What's the resolution requirement?
Any acceptance of deposits from members requires a resolution in a general meeting. For eligible public companies taking money from the public, it must be a special resolution.
Right. And the primary disclosure mechanism is the circular, using Form DPT-1. This isn't just a marketing piece, it's a financial health declaration. What must it contain?
It has to contain the full, unvarnished financial position of the company. Key elements are the financials, any credit rating obtained, the total number of existing depositors, and, critically, a clear disclosure of any amount due towards past deposits.
It's basically the primary due diligence document for the potential depositor.
Yeah.
How does the company make sure this information reaches all the members?
Rule 4 mandates clear, auditable delivery methods, registered post with AD, speed post, or electronic mode. And if the company is advertising to the public, that circular has to be published in one English newspaper and one vernacular newspaper, both with wide circulation in the state of the registered office.
And central to that DPT-1 circular is the assurance provided by the auditor's certificate. This links the current invitation directly to the company's past compliance record.
Precisely. The statutory auditor must certify one of two things. Either the company has a clean slate with no defaults in repayment of past deposits or interest. Or, if a default did occur, the auditor has to certify that the company has fully rectified it and that a period of 5 years has passed since the date of that rectification. The law demands a clean 5-year look-back period if there's any history of default.
And how long does a single circular remain valid?
It remains valid only until the earliest of two dates, either 6 months from the closure of the financial year or the date of the AGM. Since the AGM usually happens before that 6-month deadline, the AGM date is often the expiry date. A fresh one is needed pretty much every year.
The regulator also needs advance warning. What's the filing timeline for the DPT-1 circular with the Registrar of Companies?
The circular has to be filed with the RSC at least 30 days before the date the company issues it to its members. This preemptive filing gives the RSC time for a preliminary review before the public invitation starts.
And beyond that initial circular, every company has to provide an annual census of its deposit liabilities using Form DPT-3. This covers more than just deposits, doesn't it?
It's significantly more. The DPT-3 return is mandatory for almost every company and must be filed by June 30th each year. Critically, it requires the company to include details of transactions that are exempted from the definition of a deposit, like loans from directors. The regulator wants a full 360-degree view of the company's entire debt structure.
Now, the Deposit Repayment Reserve Account, or DRRA, this seems to be the most vital liquidity safeguard. This is where the company proves it can meet its future obligations.
The requirement is specific and absolute. By April 30th each year, the company has to deposit a sum in a separate bank account that is not less than 20% of the amount of deposits scheduled to mature during the following financial year.
And it has to be held with a scheduled bank. Why that restriction?
To ensure the funds are held with a regulated, high-liquidity institution, it minimizes the risk of a bank failure compromising the company's ability to repay. The account has to be clearly titled as the DRRA, separate from all operating accounts.
So you absolutely cannot touch that money for anything else, even for a short-term cash crunch.
Rule 13 makes it crystal clear. The amount in the DRRA shall not be used for any purpose other than repaying deposits. This ring fencing ensures that in a cash crunch, the depositor's money is the last to be touched. Using it for anything else would be a severe contravention.
Okay, moving on to the additional conditions for those eligible public companies accepting public deposits. The first is a mandatory credit rating requirement.
Yes, when you're dealing with public savings, external validation of financial health is mandatory. The company has to get a credit rating at least once a year from an approved agency.
And what are the compliance hurdles for that rating?
The rating cannot be below the minimum investment grade. A copy of the rating certificate has to be submitted to the ROC every year with the DPT-3 return. It forces continuous financial accountability.
And if the company opts for secured deposits from the public, the charge creation rules are very precise, linking back to our earlier discussion on tangible assets.
Right. Rule 6 demands that a charge must be created on tangible assets only, within 30 days of accepting the deposit. Again, intangibles like goodwill are out. The value of this security must be independently assessed by a registered valuer and must be at least equal to the amount of deposits plus interest.
And this security has to be in favor of whom?
in favor of a designated trustee for depositors. The whole purpose of securing the deposits is defeated if the security isn't properly established and monitored by an independent fiduciary.
Let's shift focus to those operational rules that govern the company's relationship with the individual depositor then. The role of the trustee for depositors seems crucial here.
The deposit trustee is the key independent safeguard required for secure deposits. Their appointment must be done via a board resolution before issuing the circular. And a trust deed in Form DPT-2 must be executed at least 7 days prior to issuing that circular.
So the fiduciary structure has to be legally solid before the public is even invited. And what about the independence of the trustee? What are the major disqualifications?
The law ensures the trustee is not beholden to management. They can't be a director, KMP, officer, or employee of the company or its group companies. They can't be indebted to the company or have any material pecuniary relationship. It's a battery of restrictions to ensure they act solely for the depositors.
And removing them must be difficult.
Very. Once the circular is out, the trustee can only be removed with the consent of all directors present at a board meeting. And if the company has independent directors, at least one of them must be present at that meeting.
So as a depositor, what does having a trustee actually do for me? What are their primary duties?
Their duties are supervisory and protective. They supervise the creation of the security, they protect the interests of the depositors, and crucially, they have the power to call a meeting of depositors if requested by those holding at least 1/10 in value of the total deposits. It's a direct channel for depositors to organize.
Okay, what about on the depositor side? The application form itself has a requirement.
Yes, the application form must contain a mandatory declaration from the depositor stating that the deposit is not being made out of money they have borrowed. It's another layer of due diligence.
Let's address joint deposits. It's a common request. And the rules seem simple and non-negotiable.
It is clear. Deposits can be accepted in joint names, but the statutory limit is a maximum of 3 persons. No exceptions.
So a request from someone to deposit jointly with their spouse and 3 children, 5 names total, has to be rejected.
Must be rejected. The compliance team has to strictly adhere to the limit of 3.
Okay, so what's the real-world difference between the repayment clauses, jointly versus either or survivor?
This is about who can get the money back. If it's jointly, then all named depositors or their survivors must sign the receipt. If it's either or survivor, then any one of the 3 named persons can demand and receive the full repayment. And if it's first named or survivor, only the primary account holder can operate it.
Good to know. And once the money is received, the company has to provide proof.
The deposit receipt. It's the primary proof of debt. It must be issued within 21 days of receiving the money. It has to detail the name, address, amount, rate of interest, and the precise maturity date.
And what about the internal record keeping? The register of deposits.
The register is the master record, kept at the registered office. Entries have to be made within 7 days of any acceptance or renewal. And for audit purposes, that register must be preserved for a minimum of 8 years from the financial year of the latest entry.
8 years. That's a long time. Now, what if a depositor wants their money back early? Let's talk about premature repayment.
The law permits it, but subject to a financial penalty. It's to compensate the company for disrupting its financial planning.
What's the minimum lock-in period, and what's the standard penalty?
Premature repayment is allowed only after a minimum of 6 months has passed. If it happens after 6 months, the company pays interest at a rate that is 1% lower than the rate originally agreed upon.
So if the agreed rate was 8%, they'd get 7%. It's a clear deterrent against treating these like savings accounts.
Exactly. However, there are exceptions where that 1% reduction is waived. Things like the death of the depositor, or if the company itself calls for the repayment. In those cases, the full agreed interest is paid.
And what if a depositor wants to renew their deposit early, maybe because interest rates have gone up?
Premature renewal for a higher rate is permitted, but only if the new renewal period is longer than the remaining unexpired period of the existing deposit.
We have to conclude this audio lecture by establishing the consequences of failure. The penalties under the Companies Act are designed to be severe, reflecting the high fiduciary responsibility involved.
Yes. Let's start with Section 74, which dealt with deposits accepted before the 2013 Act came in. Companies had to file a one-time statement in Form DPC-4 and repay those deposits within 3 years.
And failure to comply with those transitional rules triggered heavy punishments under Section 74(3).
What are we talking about in terms of liability? The fine for the company is a minimum of 1 crore rupees, or twice the deposit amount, whichever is lower, up to 10 crores. And for the officer in default, it's intensely punitive. Imprisonment up to 7 years and a fine from 25 lakhs up to 2 crores. The mandatory imprisonment is a serious deterrent.
And what about for ongoing violations under the current act? Section 76A governs things like failing to repay on time.
Let's take the City Bakers Limited example, where they failed to repay 50 crores in deposits. This is a failure to repay within the specified time, triggering 76A.
So what happens to the company?
For City Bakers, the fine is the lower of 1 crore or twice the deposits, which is 100 crores up to 10 crores. And this is in addition to repaying the entire 50 crore principal plus all outstanding interest.
And for Swathi, the officer in default?
Swathi faces the same severe personal liability, a fine from 25 lakhs to 2 crores, and imprisonment which may extend up to 7 years. The law holds management personally liable.
What's the gravest escalation? When a contravention crosses the line from a technical default into intentional deception or fraud.
If the regulator or the court finds that the failure was knowingly or willfully done with the intention to defraud, the liability immediately shifts to Section 447, the central section for punishment for fraud. This greatly exacerbates the severity of both the imprisonment term and the fine.
That distinction between a technical noncompliance and willful fraud is a crucial one.
Absolutely. And finally, as an immediate financial recourse for the depositor, if a company defaults, Rule 17 kicks in. The company is automatically liable to pay penal interest at the rate of 18% per annum for the entire period of delay.
This exhaustive analysis of Chapter 5 confirms that mastering deposits is mastering the interplay between legal definition, quantitative limits, and stringent procedure. For you, the learner, the key takeaways are highly numerical and procedural.
Right. Always remember the critical gatekeepers. The negative list, especially the strict conditions for director's loans, that written declaration, and the numerical cap on employee security deposits, which must not exceed the annual salary. Internalize the critical timeframes, 6 to 36 months tenure. The short-term exception requires a 3-month minimum and a 10% ceiling. The liquidity safeguard demands depositing 20% of maturing deposits into the DRRA by April 30th. And administratively, you're limited to a maximum of 3 joint depositors, with the register preserved for 8 years.
And don't forget the required forms and their deadlines, which act as checkpoints in the compliance calendar. DPT-1 for the circular, filed 30 days before issue. DPT-2 for the trust deed, executed 7 days before the circular, and DPT-3 for the annual return, filed by June 30th, covering all exempted loans as well. The entire architecture of this framework is a delicate balancing act. It allows companies to tap into crucial capital sources while constructing mandatory shields for investor protection. The sheer severity of the penalties under Section 76A and the threat of Section 447 underscore the fact that this is not just an administrative exercise, it is a fiduciary one. So here's a final provocative thought for you to consider as you apply this knowledge. Given that the distinction between a technical default under Section 76A and an intent to defraud under Section 447 often relies on proving management's intent, what are the most critical internal controls, beyond mere filing deadlines and calculation checks, that a compliance officer must establish to prevent any contravention from ever being perceived as knowing or willful? Think about the layers of practical, documented justification needed to build a defense against a fraud charge. Thank you for tuning into this crucial audio lecture on corporate laws. Always study smart and master your future.
Don't forget to like and subscribe.